Hello everyone, and welcome back to Morph of Dread. I can picture some of you already tucked into bed, or maybe you're sitting in the quiet shadows of your home. Wherever you are, and whatever hour it is, I'm glad you've chosen to be here. If these stories help you find a strange kind of peace or help you drift off, please hit that like and subscribe button. It truly means a lot. Now, dim the lights, get comfortable, and let's see what form tonight's dread will take. There's a courtroom that still stands in Salem, Massachusetts. Tourists walk through it every day, taking pictures, reading plaques. But there's something most visitors never notice. On the judge's bench, carved into the wood where only someone sitting in that specific seat would see it, there's a phrase in Latin. Justitia omnibus. Justice for all. The carving was made in 1692, the same year that the courtroom sent 19 innocent people to their deaths. The same year respected judges, educated men, pillars of their community, systematically condemned people they knew were probably innocent. And they did it legally, following proper procedure, with paperwork and witnesses and everything a court of law requires. The question that haunts legal historians isn't why a mob killed innocent people. Mobs do terrible things. The question is how a legal system, with judges and rules and procedures designed to protect the innocent, became the machinery of murder. How justice became a word that meant its opposite. And how everyone involved convinced themselves they were doing the right thing, even as the bodies piled up. This wasn't just about Salem. This wasn't just about witch trials. What happened there was a perfect, terrible example of something that happens over and over across history. A legal system that doesn't break down. A legal system that works exactly as designed. But designed for cruelty. Designed to make horror systematic, official, and acceptable. Because when cruelty wears the robes of justice, when it speaks in legal language and follows proper procedure, it becomes something far more dangerous than simple violence. It becomes normalized. It has become a tradition. It becomes law. To understand how this happens, you have to go back to a time and place where everything seemed normal. Where the system seemed to be working exactly as it should. Massachusetts Bay Colony in 1691 was, by the standards of its time, a functioning society. It had laws, courts, elected officials. It had towns with churches and schools. It had families who'd been there for generations, building farms, raising children, creating communities. The legal system was based on English common law, modified for colonial circumstances. There were magistrates, formal trials, records kept in careful handwriting. This wasn't a lawless frontier. This was a place that prided itself on order, on godliness, on doing things the right way. The people living there weren't monsters. They were farmers and merchants, mothers and fathers. They worried about their crops and their children's education. They attended church on Sunday. They helped their neighbors build barns and harvest fields. By every measure they could see, they were good people living in a good community under good laws. And that's exactly why what happened next is so disturbing. In February 1692, two young girls in Salem village began having fits. They screamed, contorted, claimed to see things others couldn't see. The local doctor examined them and found no physical cause. In a community where illness was frightening and poorly understood, where infant mortality was high and disease could wipe out entire families, unexplained sickness was terrifying. The doctor made a diagnosis that seemed reasonable within his worldview. The girls were bewitched. Now, here's where the story usually gets told wrong. Popular versions make it seem like the community immediately went crazy, like reason disappeared overnight. But that's not what happened. What happened was worse. Because the reason didn't disappear. The legal system didn't break down. Instead, the community did exactly what they'd been taught to do when a crime was committed. They reported it to the authorities. And the authorities did exactly what they were supposed to do. They investigated. The magistrates who took up the case weren't random zealots. They were respected men. John Hathorne had been a magistrate for years, known for fairness in property disputes and criminal cases. Jonathan Corwin came from one of the colony's leading families. These were the people the community trusted to administer justice. And they approached the witchcraft accusations the same way they'd approach any other crime. With questions, with examination of evidence, with proper legal procedure. The girls were asked who had bewitched them. They named names. 3 women, Sarah Good, a homeless beggar, Sarah Osborne, an elderly woman who rarely attended church, and Tituba, an enslaved woman in the minister's household. Notice who got named first. The most vulnerable. The people on the margins. The ones with the least power to defend themselves. The 3 women were arrested and brought before the magistrates for examination. This wasn't a mob grabbing people off the street. This was an official legal process. Warrants were issued. Constables made arrests. The examinations were held in the meeting house, with the entire community watching. Everything was done by the book. And this is where something subtle but crucial happened. Something that would transform a legal system designed to find truth into a machine designed to confirm what people already believed. The magistrates began their examinations with a particular assumption. Not that the accused might be guilty. That they were guilty. The purpose of the examination wasn't to determine if witchcraft had occurred. It was to force a confession. The questions weren't neutral. Why do you hurt these children? Not did you, but why do you? What evil spirit are you familiar with? The guilt was assumed. The only question was the details. 2 of the women denied everything. Sarah Good and Sarah Osborne insisted they were innocent, that they'd done nothing wrong. But Tituba, perhaps understanding her vulnerable position better, perhaps hoping that cooperation would save her, confessed. And her confession changed everything. She didn't just admit to witchcraft. She elaborated. She described a conspiracy. Other witches, meetings, a dark man who made her sign a book. She gave the magistrates exactly what they wanted, confirmation that this wasn't just isolated incidents, but a hidden network of evil operating in their community. The legal system now had a confessed witch. Someone who'd admitted, in open court, that witchcraft was real and that there were more witches to be found. This confession became the foundation for everything that followed. Because now it wasn't just scared girls making accusations. Now there was legal testimony from someone who claimed direct knowledge. More accusations followed. More examinations. More arrests. And the legal system processed each one with the same careful attention to procedure. Warrants issued, arrests made, examinations conducted, testimony recorded. Everything is documented. Everything is official. Everything is legal. But the rules of evidence had quietly shifted. Normal legal standards, the ones that would apply to theft or assault, didn't seem to apply here. In a normal case, you needed witnesses who saw the crime happen. You needed physical evidence. You needed proof beyond just accusation. But witchcraft was, by its nature, invisible. The crime happened in the spiritual realm. So how could you prove it by normal means? The magistrates found an answer: spectral evidence. The idea that a witch could send out their spirit, their spectre, to torment victims even while their body was somewhere else. So if the afflicted girls said they saw Sarah Good's spectre choking them, that was evidence. Even if Sarah Good was sitting right there in the courtroom, clearly not touching anyone. Her invisible spirit was doing it. And only the afflicted could see these specters, which meant only their testimony mattered. Think about what this did to the concept of defending yourself. How do you prove you didn't do something invisible? How do you defend against accusations of spiritual attack when the accusers are the only witnesses and their visions are accepted as fact? You can't. There is no defense. The system had created a category of crime that was impossible to disprove. And this is where the legal system's veneer of respectability became its most dangerous feature. Because this wasn't a mob. Mobs can be dispersed, reason can be restored. This was law. This was official. These were courts following procedure, keeping records, conducting themselves with all the dignity and formality that made law respectable. The accused would sit in the courtroom, surrounded by their neighbors. People they'd known for years. And one by one, those neighbors would testify. That time 5 years ago when they'd argued about a property line, and the cow died shortly after. That time she looked at them strangely in church. That time their child got sick after she walked past their house. All of it presented as evidence of witchcraft. All of it taken seriously by educated magistrates who wrote it down in careful legal language. The community was being taught something. They were learning that their petty grievances, their suspicions, their fears could be transformed into legal testimony. That the law would listen. That the courts would act. And so more accusations came. People who'd been arguing with neighbors suddenly realized those neighbors might be witches. People who'd always been a bit different, a bit odd, suddenly found themselves named. By May, the jail was full. Dozens of accused witches, including people no one would have suspected. Not just the marginal and poor, but church members, property owners, even a former minister's wife. The accusations had spread beyond any logical pattern. But the legal system kept processing them. Arrest, examination, imprisonment. All proper. All official. All legal. The colonial governor, William Phips, returned from England that May to find the crisis in full swing. He did what any responsible official would do. He created a special court to handle the backlog. The Court of Oyer and Termina. To hear and to determine. He appointed respected judges, men of standing and education. He gave them authority to conduct proper trials and pass judgment. The first trial was held on June 2, 1692. Bridget Bishop stood accused. The trial followed all the proper forms. There was a jury of prominent men. There were witnesses who testified. The accused was allowed to speak in her defense. Everything looked like justice. Everything looked like a proper trial. But the evidence admitted was spectral evidence. Dreams and visions. Claims of invisible torments. And the jury, good men who took their responsibility seriously, listened to this evidence. They deliberated. And they found Bridget Bishop guilty. She was hanged on June 10, legally executed. After a proper trial. Following all the correct procedures. And the machinery of legal murder was now fully operational. 4 more trials in July. 5 guilty verdicts. 5 executions. The court reconvened in August. 6 more trials. 6 more guilty verdicts. 6 more executions. September brought 8 more. The judges were working efficiently now. The procedures were streamlined. The court was functioning smoothly. Each execution was carried out with legal precision. The condemned were given time to confess, as was proper. They were allowed final words. The hangings were done correctly, according to law. Records were kept. Death certificates issued. All the paperwork properly filed. The system was working exactly as designed. And that was the horror of it. Because at no point did the legal structure break down. At no point did the judges abandon law and resort to mob violence. They followed procedure at every step. They held trials. They examined evidence. They deliberated. They passed sentences. They executed the condemned. All legally. All officially. All with the full weight of governmental authority. Some of the accused confessed, hoping mercy would follow. They were right. Those who confessed were imprisoned but not executed. Because a confession proved the court was right, that witches existed, that the proceedings were justified. Those who confessed validated the system. Those who maintained their innocence were killed. Because their denial proved their guilt. A true witch would lie, wouldn't they? Their refusal to confess was seen as stubbornness, as the devil's influence kept them from admitting the truth. Innocence was proof of guilt. Guilt was proof of guilt. There was no logical path to acquittal. The most horrible moment came in September when Giles Corey, an 8-year-old man, was brought to trial. He refused to enter a plea. Not guilty or guilty. He simply refused to participate in the legal proceeding. Under English law, a trial couldn't proceed without a plea. So the law had a solution for this problem: pressing. The accused would be placed under heavy stones, the weight gradually increased, until they either entered a plea or died. Giles Corey was pressed for 2 days. Slowly crushed under increasing weight. Asked repeatedly if he would plead. He never did. He died, legally tortured to death, because the law said this was the proper procedure for someone who refused to enter a plea. The awful thing is that Corey probably understood the system better than anyone. If he entered a plea and was found guilty, his property would be forfeit to the government. His family would be left with nothing. But if he died before trial, his property would pass to his heirs. So he chose to be slowly crushed to death to protect his family from a legal system he knew was designed to take everything from him. Think about what that means. An 8-year-old man chose to be tortured to death because that was the better option compared to letting the legal system run its course. The law had become so perverted that being crushed under stones was the more merciful choice. By October, over 150 people had been arrested. 19 had been hanged. 1 had been pressed to death. 4 had died in prison awaiting trial. More trials were scheduled. The court was continuing its work. And then something changed. Not because the legal system suddenly recognized its error. Not because the judges had a moral awakening. But because the accusations finally touched the wrong people. The afflicted girls started naming the wives of wealthy merchants. The relatives of prominent ministers. People with connections, with power, with the ability to push back. And suddenly, people in authority started questioning whether spectral evidence was really reliable. Whether dreams and visions should determine life and death. Notice what it took to stop the machinery. Not the deaths of 19 people. Not the torture of an old man. Not the imprisonment of over 150 innocent people. But the moment the system threatened those with power, suddenly the evidentiary standards became important. Suddenly people remembered that accusations should be proven, that invisible evidence might not be trustworthy. Governor Phipps dissolved the Court of Oyer and Termina in October. He created a new court with stricter rules about evidence. Spectral evidence was no longer admissible. And suddenly, with that one change, the convictions stopped. Of the 52 cases heard by the new court, 4 to 9 were acquitted. 3 were found guilty but immediately pardoned. The same judges, the same accusers, the same community. But different rules about what counted as evidence. and the whole machinery of legal murder ground to a halt. By May 1693, everyone still in prison was released. The witch trials were over. 19 people had been executed. All legally. All following proper procedure. All with the full authority of the legal system behind each death. The aftermath is telling. There was no mass punishment for what had been done. The judges weren't removed from office. Most went on to have respected careers. The accusers weren't held accountable. Many lived long lives in the community, never facing legal consequences for their false testimony. Some people apologized. In 1697, the trial jury issued a statement expressing regret. In 1706, Anne Putnam, one of the chief accusers, made a public apology. She claimed she'd been deluded by Satan. Notice that even her apology shifted blame away from herself. It wasn't that she'd lied. It was that she'd been tricked by supernatural forces. Even in confession, accountability was avoided. The colony passed laws providing restitution to the families of the executed. Money for the wrongful deaths. As if you could put a price on what had been done. As if compensation made it right. But the deeper question remained unanswered. How did a legal system, designed to protect the innocent, become the instrument of their murder? How had educated, respected judges presided over trials that sent people to their deaths based on dreams and visions? How had an entire community participated in legal proceedings that everyone now agreed were unjust? The answer lies in understanding that the system didn't fail. It worked. It worked exactly as it was designed to work once certain assumptions were accepted. Once you accepted that witchcraft was real and posed a threat to the community. Once you accepted that normal rules of evidence didn't apply to invisible crimes. Once you accepted that the testimony of the afflicted was reliable. Once those premises were in place, everything that followed was logical, legal, and systematic. This is what makes legal cruelty so much more dangerous than simple violence. Violence is obviously wrong. It triggers moral resistance. But legal cruelty comes wrapped in the language of justice. It follows procedures. It has rules. It looks like the system working, not the system failing. And because it looks like justice, good people participate. They serve on juries. They testify as witnesses. They enforce sentences. They do their civic duty. And they tell themselves they are upholding the law, maintaining order, and protecting the community. The judges in Salem weren't uniquely evil. They were products of a system that had been carefully constructed to normalize cruelty as justice. They were following legal precedents from England, from biblical law, from centuries of legal tradition around witchcraft prosecution. They were doing what judges were supposed to do, applying the law as it existed. The problem was the law itself. The law that said some crimes didn't need normal proof. The law that said some testimony was inherently reliable. The law that said protection of the community justified extreme measures. Once those principles were embedded in the legal structure, the murders that followed were inevitable. And Salem wasn't unique. The same pattern appears throughout history. Legal systems that normalize cruelty through systematic procedure. The Inquisition, with its careful documentation and legal protocols for identifying heretics. The fugitive slave laws in America, where catching and returning escaped slaves was legal duty, enforced through courts with judges and warrants and proper procedure. The Nuremberg laws in Nazi Germany, which didn't break the legal system but used it, creating systematic discrimination and eventual genocide through proper legal channels. Each of these systems looked different. Different times, different places, different victims. But the mechanism was the same. Take a legal system. Embed assumptions that dehumanize a particular group or validate a particular type of cruelty. Create evidentiary rules that make defense impossible. And then let the machinery of law run its course. The people operating these systems often genuinely believed they were administering justice. They followed procedures. They kept careful records. They deliberated on evidence. They did everything right according to the rules they'd been given. The cruelty wasn't a bug in the system. It was a feature. This is why legal reform is never just about changing specific laws. It's about examining the assumptions embedded in the legal structure itself. What counts as evidence? Who is considered a reliable witness? What is the burden of proof? Who has the right to defend themselves, and how? These seemingly technical questions of legal procedure determine whether a legal system protects the innocent or systematizes their destruction. Salem's legacy isn't just about witch trials. It's a warning about how easily legal systems can be perverted to serve cruelty while maintaining the appearance of justice. How educated people can participate in horror while convinced they are upholding the law. How entire communities can normalize the abnormal when it's dressed in legal language and carried out through proper procedure. The courtroom still stands. The judge's bench with its carved promise of justice for all is still there. Tourists take pictures. School groups learn about the witch trials as a historical curiosity, a primitive mistake from a less enlightened time. But the mechanism that created Salem hasn't disappeared. It exists wherever legal systems embed assumptions that certain people or groups deserve less protection. Wherever evidentiary standards shift based on the accused's identity. Wherever legal procedure is used not to find truth but to confirm predetermined conclusions. Wherever the machinery of law is turned toward cruelty while maintaining the appearance of justice. The specific form changes. The victims change. The legal justifications change. But the pattern remains. A legal system that normalizes cruelty. That makes horror systematic. That allows good people to participate in terrible things while convinced they are upholding justice. And the most disturbing part is how invisible it is to those inside it. The judges in Salem didn't think they were murderers. They thought they were protecting their community. The juries didn't think they were condemning innocence. They thought they were carefully weighing evidence. The witnesses didn't think they were lying. They believed what they said. Everyone was following the rules. Everyone was doing their part. Everyone was convinced that what they were doing was not just legal, but right. And 19 people died because a legal system had been constructed to make their deaths inevitable while calling it justice. That carved phrase on the judge's bench, Justitia omnibus, justice for all, remains. A promise and a warning. A reminder that the word justice can mean anything. That legal system can be designed to protect or to destroy. That procedure and formality and proper documentation don't make something right. They just make it official. The hidden legal system that normalized cruelty wasn't hidden because it operated in secret. It was hidden because it looked like justice. It spoke the language of law. It followed proper procedure. It had the authority of the state behind it. And that made it far more dangerous than any mob, any riot, any obvious lawlessness. Because when cruelty becomes legal, when it becomes systematic, when it becomes procedurally correct, it becomes almost impossible to resist. To oppose it is to oppose law itself. To question it is to question order. To resist it is to mark yourself as a threat to society. The machinery sits waiting, in legal structures, in procedural rules, in assumptions about evidence and testimony and guilt. Waiting for the next crisis, the next fear, the next opportunity to transform cruelty into justice. To make horror legal. To let good people participate in terrible things while convinced they are doing their duty. The courtroom stands empty now, a museum piece. But the system it represents never really ended. It just found new forms, new victims, new legal justifications. Always with proper procedure. Always with careful documentation. Always calling itself justice. Always hiding in plain sight behind the respectable facade of law.